Good morning, Your Honor. Liane Wakayama appearing on behalf of defendant Nickolas Carter. Also on Zoom is my partner, Dale Hayes Jr. He's going to be handling the anti-SLAPP hearing. I'm handling the summary judgment. Mr. Carter did want to be here today. Unfortunately, he's occupied. He's in tour in Europe and actually currently on stage as we speak.
Oh, good morning.
Morning, Judge.
Good morning.
Good morning. Good morning, Your Honor. John Kawai for plaintiff Ashley Repp.
Good morning.
Good morning, Your Honor. Mark Boscovich on behalf of plaintiff Shannon Ruth.
Good morning.
Good morning, Your Honor. Jamie McAnally, also on behalf of plaintiff Shannon Ruth.
Good morning. Okay. All right. So we've got a couple things on. I think it would make sense to start with the anti-SLAPP, given that we had a hearing and I requested supplemental briefing, which parties have done. And then after you all, I've still got another set of substantive motions in another case. So total on all the motions in your case on each side, I'm gonna have to limit you to 15 minutes of argument. And that's not 15 minutes for this motion, but 15 minutes overall. So I'll tell you what I'm inclined to do, which I'll, you focus maybe, so we're back on plaintiff counter defendant Repp's motion to dismiss pursuant to the anti-SLAPP. With, like I said, parties have now filed supplemental briefing, which, to be clear, I have reviewed, as well as went back through the original briefing as well. And I am inclined to grant AR/Ms. Repp's special motion to dismiss pursuant to NRS 41.635 for all the reasons set forth in briefings filed on her side. So welcome arguments. You're certainly welcome to save for rebuttal if you're okay with that initial inclination, or you can use some of your time if you'd like as well.
Your Honor, so speaking on behalf of plaintiff Ashley Repp, I would largely, I will submit on the papers.
Okay.
And Judge, Your Honor, respectfully addressing the issues that you asked us to supplement. First and foremost, Judge, I submit that Ms. Repp's supplemental briefing generally just cited the case law and asserted the arguments asserted in the initial briefing. She did submit a declaration filing. It was relatively bare bones outside of her age and saying that she believes Nick Carter sexually assaulted her, which again runs completely afoul of all of her sworn statements to the Marathon Police Department back contemporaneous when this happened, when she told them over and over again he did not assault her, and that she was only reporting the matter to retaliate against him because he had a quote unquote new girlfriend. But one of the arguments that was raised in the reply for the first time is Repp argued that somehow, as you know, Your Honor, these anti-SLAPP laws have some pretty serious timing and deadline constraints and parameters to them. And Repp argued that we somehow waived the right to have them establish their burden with the initial motion. And I cited the case law on that. And counsel seems to think that because I followed your order in submitting supplemental briefing, that I've somehow waived that objection. And given your inclination, obviously, I want to make a clear record on that before I get into kind of what you want to supplement. And we are absolutely not waiving that. And, and feel that this matter should have only really been continued had Ms. Repp pointed out that certain discovery needed to be performed, which wasn't the case. Your Honor pointed out her motion was bare bones and asked us to brief some additional legal issues. Specifically, Your Honor, as it relates to the Florida law, Judge, what Ms. Repp is trying to do here is summarily adjudicate probably the most material fact in this case in a proceeding like this. And I say proceeding like this, Judge, because this is a preliminary proceeding, first and foremost. I mean, the case law that discusses anti-SLAPP laws and proceedings, no discovery's been performed, pleadings haven't really been filed. To say that there's been limited amount of time to collect evidence is an understatement. And notwithstanding that, Your Honor, we've submitted tens of declarations that all refute Ms. Repp's bare bones allegations, her sworn statement that swallows what she said, the testimony of third-party witnesses attesting to her participation in the conspiracy that's already withstood anti-SLAPP scrutiny twice now, Your Honor. Additionally, tens and tens of social media posts evidencing Ms. Repp's grooming at the hands of the Schumans, Your Honor. And not only that, her being coached, her getting on, video Zooms with Aaron Carter, someone she didn't even know barely. Judge, I mean, the evidence is just ample from Mr. Carter's side. And conversely, from Ms. Repp's side, we have a bare bones declaration, which we submit in the initial pleadings to Your Honor. That's not appropriate. She can't just rely on her declaration if it flies in the face, if there's contradictory evidence in the record, which, Your Honor, I don't know exactly how many exhibits we have, but we have well over 100. She cites the two other deposition transcripts, but they're completely collateral, Your Honor. Basically, she cites them, based on for the notion that general members of the public know what statutory rape is, which is not at issue in this proceeding, Judge. She's conflating the two prongs. I understand, Your Honor, that Your Honor wants to accept her declaration despite her sworn testimony and say that she's established a good faith belief in the truth of her statements. But that's just the first prong, Your Honor. To prevail in anti-SLAPP, she has to prevail on the first prong and the second prong. I cited that case for Your Honor. And the second prong involves my client, Your Honor. You can't consider her competing evidence. You can't weigh credibility. All he has to do is produce prima facie evidence to establish a probability of prevailing. And Your Honor, all of the cases describing this burden have described it. All you have to do is establish your claims have minimal merit. And I would submit to you, Your Honor, that given the junction of the phase of this case, I don't know how many declarations we've submitted, the fact this has gone through anti-SLAPP vetting twice, again, the third-party witness, and more importantly, on her own sworn admissions. When she went to law enforcement, those are admissions under penalty of perjury she's making to that police department, where she says, he absolutely did not assault me. We have all the witnesses that were present in Marathon during the trip that said that she was having a great time, that she wanted to have sex with Nick, that she was having sex with multiple people. And we don't submit that, Your Honor, to bash her, as counsel suggests. We submit that because if somebody's in a location and being assaulted by one individual, it stands to reason that she wouldn't hang out and party and have sex with other individuals, that's also at that locale. She would get out of there, so to speak. Your Honor, the other evidence that I'm sure counsel is going to bring up when he argues is our quote unquote judicial admissions. And again, Your Honor, I submit to you that the arguments set forth in this, they just cite to the general law. They don't get to the focused nature of these cases and how those cases apply to our specific set of circumstances. And specifically, Judge, he cites to the cases, but he bolds the general language and leaves out the focused language that hurts him. And when it comes to judicial admissions, Your Honor, you cannot consider allegations and pleadings, which he's doing, as judicial admissions when the admission is qualified by some sort of reservation or explanation, Your Honor. That's exactly what we have here. It's a case by case, quote unquote, will depend on the circumstances of every case, consideration that Your Honor has to make whether or not these pleading allegations can actually operate as judicial admissions. And I just want to give you a little taste, Your Honor, of what he is saying, where Nick, quote unquote, admitted to raping her. Repp alleged Carter committed sexual assault against her 19 separate paragraphs in her complaint. We expressly denied all 19 of those. With our affirmative defenses, we have 11 separate affirmative defenses denying any wrongful conduct and maintaining that our encounter with her was absolutely consensual. And notwithstanding those denials, Your Honor, and affirmative defenses, we have as cited in his own brief, we have very detailed paragraphs that outline the specific circumstances surrounding Nick's encounter with Ms. Repp, how deceitful she was, how she used a fake ID to access the compound, how she confirmed her age over and over. Her best friends at the time confirmed this in testimony, Your Honor, that we've submitted. They confirmed that she's a deranged Nick Carter fan that was catfishing individuals, that she wore this sex as a badge of honor for years and years following, leaving Marathon. It was a strategic and deliberate attempt to circumvent the family and have sex with Nick and have sex with Aaron. That's exactly what she did. All of her friends have testified to that, Your Honor. And that's what we've alleged. So how we get from that to counsel arguing we admitted to rape is beyond me. He simply wants to use a single criminal statute, the rape statute from Florida, to say, okay, because you can't consent to sex in Florida on a criminal charge, somehow that's going to operate to dispositively establish a fact in a civil lawsuit 20 years later across the country, Your Honor. And there's no cases that support that. In fact, that's what you asked us to do here, Judge, and that's what I did. And he didn't do it. You gave him the opportunity. All he did was, again, cite to the Florida statute. We get it. Nobody disputes the fact that Florida has a rape statute. Nobody disputes the fact that 15-year-olds can't consent. But what he leaves out of that is that the prosecutor's office has the absolute inviolate discretion to decide who am I going to charge and what am I going to charge him with. After they considered all the facts and you have that police report in front of you, not only do you decide, I'm not going to charge Nick with anything, he admonished this individual and said, I should charge you, given your deceit and your behavior and what you did to this family in Marathon, Your Honor. And just one moment here, Judge, if you could let me look to my notes. The other thing you asked us to, I cited to also, I don't want to pass up on this. Also in Florida, the general rape statute, a 12-year-old can consent. So clearly the Florida legislature did not intend to have a bar rule. And I submit to you, it doesn't matter anyway. It's a criminal case. And I cited the California case and I quote it, there is no hard and fast rule as to the age at which a person obtains the capacity to consent to bodily invasions. Capacity exists when the minor has the ability of the average person to understand and weigh the risks and benefits. That's a California case citing to Prosser and Keaton on torts, which Nevada routinely cites to. And more importantly, Your Honor, Nevada relies heavily on California law when it comes to anti-SLAPP principles, including these evidentiary issues, Judge. And the Honia and Coley cases, Coley's from Florida, Honey's from Nevada, are directly on point. And he fails to even address them. You asked us to do this, and he didn't do it. And now we're back to you, on the continued hearing, and his mantra remains the same. Nick raped her. He admitted to rape. He didn't admit to rape. He admitted to being tricked into having sex with an individual that showed up at his house professed to be a manager of an internet website, gave a fake ID, and then came inside and partied with everybody for weeks and weeks and had sex with various individuals, some of which being over 18 and just like Nick. They're not being sued, Your Honor. Your Honor, so we submit to you that she has not satisfied her first burden. Her sworn statements to law enforcement swallow any ability for any right for her to argue this was good faith and it wasn't made. How can she come to you and say, I didn't make this with any knowledge of the falsity of it, when she made sworn statements to the police department on the exact same issues that completely contradict what she's saying here before you today, Judge? So I don't, are you offering me any chance of rebuttal, Your Honor? I know it's not my motion, but I would like a moment to address any arguments counsel makes. In response, if I'm not allowed rebuttal, I'll keep talking to you, tell me to shut up.
Well, you have a time limit, so how you use that's up to you. You're almost at 10 minutes in total. So again, to be clear, that
all right, I would like to leave my partner some time. Then last point, Your Honor. The statement she's making are not that Nick committed statutory rape, even though he was never charged on the statute. I still would disagree with that. She's calling him a serial rapist and that he raped other people, and she admits no personal knowledge of this. She submitted no evidence to support those statements. So those statements by themselves should withstand anti-SLAPP scrutiny, Your Honor, and I'll submit on that. I appreciate your time, Judge.
Thank you. Any argument in opposition or in rebuttal?
I obviously, Your Honor, I have things to say about that. We were given a very clear, discrete assignment of things to supplement on. And, obviously we did provide the relevant statutory rape law at the time, and their exact terms, including the fact that ignorance or belief as to age was not a defense under Florida law. We provided dictionary definitions from multiple sources that statutory rape is a form of rape. And the reason that it's important, it goes to both prongs of the anti-SLAPP analysis, as I believe Your Honor already recognizes based on the tentative number one, the first prong, whether it was a truthful statement or made without knowledge of its falsity, that's pretty incontrovertible here. He admits and it's important that it's a judicial admission. So I'm not really clear what counsel thinks I'm arguing that they've waived, but one thing that, one consequence of a judicial admission, which is, as the case law shows, it's a deliberate, clear, it's a statement basically submitted to the court under the studied supervision of counsel, and the case law, which talks about, whether something's an equivocal statement, they're usually talking about something like a statement made in a deposition or, under the stresses of cross-examination or something like that. So anyway, we have basically incontrovertible judicial admissions supporting the fact that the statutory rape law was in fact, or that violation was admitted to. And anyway, I'll leave it there. I'm sorry, the second prong, whether it goes to him being able to prevail on his action. I mean, obviously, we're looking at statements he's making in his counterclaim. The First Amendment, the bar is actually, substantial accuracy, and there we have here a literal violation of a statute. Therefore, he cannot prevail on any of his claims because obviously substantial truth being a defense to defamation, it's also a defense to the other causes of action asserted, such as, negligent interference with a contract or with, intentional infliction of emotional distress. The First Amendment bars all of those.
Tell me about the claim or argument rather, that she made statements using words like serial rapist or he raped others.
I believe that those are also contained in his, of course, he refers to it as a conspiracy. And I'm sorry, Your Honor, because that wasn't in the, he refers to other people making similar statements online. And so that's where she got that good faith belief from.
Thank you. Court is going to grant plaintiff / counter defendant AR Ashley Repp's now supplemental, or grant the motion, the anti-SLAPP motion, for the reasons set forth in the briefs. I'm not going to read through all of those, but I'm going to touch on a few of the primary points. But Mr. Kawai, you'll prepare a very detailed order. There's one point I disagree with, but so I wanted to mention that before. It's subsection 4 of the arguments in the supplemental. Car's not a stop from that theory that no court has recognized. I agree that no court has recognized that theory, but he's not, judicial estoppel doesn't apply there. However, certainly truth is an absolute defense. Statutory rape, calling somebody committed statutory rape is, under Florida law, based on Carter's own judicial admissions. They did have sex. They had sexual relations, and she was a minor, as old as she was at that time. I can't remember exactly how old she was, but it's set forth in detail. So these arguments about, her having sex with other people, her being deceitful, are to a large extent wholly irrelevant to what's issue with this particular motion. So the prongs are clearly met. There's the good faith belief. and that defendant has not provided prima facie evidence, probability of prevailing on the merits. You know, a lot of the arguments made in Carter's briefs and here today may very well be, you know, go to impeachment, lack of damages, merits of Ms. Repp's actual claims, but none of those, you know, based on everything, none of that defeats the anti-SLAPP motion in these particular circumstances. The fact that there was not a criminal prosecution, again, that's also, if not wholly irrelevant, almost entirely irrelevant. That's not a defense. Defendant admitted they had sex. The birth date, her birth date, and the date that they had those sexual relationships undisputed. And all these arguments made again are, you know, if not irrelevant, don't defeat the motion itself. Common dictionary definitions are certainly persuasive and used, you know, as court can take judicial notice. People use the phrase statutory rape, and a person who commits statutory rape as a rapist. Again, I'm not saying out loud all the reasons, but incorporate all the reasons other than the one I specifically disagreed with. Make it detailed, submit it to everyone else on the other side. Thank you.
I will. Thank you very much, Your Honor.
Thanks, Judge.
Okay. So now we have a defendant motion for summary judgment on plaintiff Shannon Ruth's claims. I'm inclined to deny this one without prejudice, based primarily on 56D relief. Alternatively and or additionally, because genuine issues of material fact exist. You know, the motion relies on numerous, and the reply also brings in declarations not included with the motion. Plaintiff Ruth has certainly been deposed, may have some issues with credibility and contradictory answers, but and contradictions with other witness declarations are, you know, at this stage, credibility and contradictory testimony, you know, that leads to genuine issues of material fact. Again, many of the witnesses haven't been deposed. Discovery is still open. I don't buy plaintiff's argument about the plaintiff being somehow taken advantage of at her deposition. I assume she was represented by counsel at the deposition, although I have to say when I looked at the transcripts, portions of the transcripts both sides provided, at least the portions that I looked at, I didn't see the attendance page. But I have to assume she's represented by counsel, and you know, this argument that she's taken advantage of at her deposition somehow by opposing counsel, I don't buy that, but that doesn't mean I'm going to grant summary judgment. So defendant has what, about 5 minutes or so? Yeah, 5 minutes or so.
Thank you, Your Honor. I'll be quick. It's been 19 months since Ms. Ruth brought this lawsuit against Mr. Carter. It's been 19 months of us having to obtain evidence to prove that she was not sexually assaulted over 23 years ago. And I'm sure this court can appreciate the tremendous task that that took. And we did it. We have over a dozen witnesses, all precipient witnesses, who testified that based on their personal observations after the February 25th, 2001 concert, her accusations are factually impossible. Why? Because the Backstreet Boys immediately left the venue, the Tacoma Dome, and Nick Carter was specifically spotted exiting his tour bus at the Four Seasons Hotel by fans who left the concert early and followed him to the venue. That is not disputed by Ms. Ruth. None of that evidence is disputed by Ms. Ruth. In fact, she uses some of that evidence because they're memorialized in fan posts that were posted on a fan site days after the concert, specifically Molly Hawkup's, which is March 1st, 2001. Your Honor, the real purpose of this lawsuit is that Shannon Ruth is using it and has used it as a catalyst to garner her 2 minutes of fame. That's why she did a press conference the day she filed. That's why she has utilized her time instead of discovering this case to participate in not one, but two different so-called documentaries. And she didn't start conducting discovery until the day we filed this motion for summary judgment. And 2 months after the fact, what does she have? She only has her own self-serving contradictory testimony, which is insufficient to withstand summary judgment as held precedent by our court in Aldabi v. Adams and Sergersa versus Brown. And it certainly doesn't create a genuine issue of material fact. Plus, on a purely legal grounds, her NIED claim fails as a matter of law, which we've moved on summary judgment for that as well. She doesn't have a standalone viable claim. She's not a bystander at all. So that claim doesn't exist. And she hasn't provided a shred of evidence to link what she alleges happened 23 years ago with damages that she has suffered. The first and only time that she goes to treatment is self-reporting in May of 2020, after the Schumans have indoctrinated her into their whole scheme to smear my client. Your Honor, we've learned through discovery as well that according to her friend Eleanor Brewer, she's tried to gain evidence and obtain it nearly 4 years ago. She's failed to do that. She even tried to bribe her friend who said no. And so what you have before you is her entire case, and her entire case rests on what happened at other concerts, which is irrelevant and inadmissible hearsay. In a last-ditch effort, her counsel tries to get 56D relief, but Your Honor, he fails to specify the reasons why this discovery has not been conducted. So consistent with Francis v. Wynn, it's not an abuse of discretion for you to deny such relief, given her complete failure to diligently pursue any discovery over the last 19 months. And we can't forget, Your Honor, this is the same person who admitted 4 different times to law enforcement that she was not raped by Nick Carter in sworn statements, who admitted on social media that she was not raped by Nick Carter to Heather Hyatt, who was unable to testify to any details beyond what her attorneys wrote for her in her complaint and her interrogatory responses at her deposition, which she was represented, Your Honor.
I mean, yeah, like I said, I assume she was, but I wanted to see who was there because they are arguing somehow that she was taken advantage of at the deputy.
It was Mr. Boscovich was present as well as the Christian Morris firm. And she even testified at her deposition, Your Honor, that it's possible she's having false memories of Nick Carter raping her. So on top of her own admissions, the record before you proves that her claims lack merit. We've proven them to be a factual impossibility, and she has not disputed that. She has not disputed the timeline that we have set in front of you with over a dozen witnesses. Yet when the cameras are on, she has no problem spilling all these fallacious details in her interviews. And that's not surprising, Your Honor, because when you look at what she's done to the very community, the very sisterhood she claims to be a part of, she defrauded them. She faked an emergency surgery to obtain money so she could go on vacation. That's exactly what she's doing here to Mr. Carter. When the legislature amended NRS 11.215 They did not want it as an open invitation for anybody and anyone to make any claims like this without any evidence and force my client to have to go through the tremendous effort, the time, and the expense to prove a negative. And he has done just that, Your Honor. He has done that over the 19 months that we have diligently prosecuted his claims and defended against her claims in this case. She has not done that. And so what she's trying to do, it's fraudulent, it's extortion, it's criminal, and enough is enough. And so we understand, I respect your Honor's inclination, but the record itself shows she has not disputed that timeline. That is a factual possibility. And at the very least, if you are inclined to deny summary judgment, we did ask for alternative 56G relief because there are many facts that remain undisputed in this case, and we would at least like those to be established at the time of trial.
Thank you very much. You'll have another minute.
Your Honor, we respectfully disagree with the representation of the facts today. The evidence viewed in the most favorable way to Ms. Ruth shows there is a genuine issue of fact as to whether this assault happened. And Ms. Brewer's testimony is a perfect example of that genuine issue of fact. Ms. Brewer testified that she was with Ms. Ruth that day at that concert, that she waited in a line with Ms. Ruth, saw an individual ask if they wanted autographs, saw Ms. Ruth be escorted by that individual away, and then she waited for Ms. Ruth in her car with her mother. And when Ms. Ruth came back, she was hysterical. Her clothes were disheveled. She observed a mark on her arm that was consistent of a photograph of a bruise that Ms. Ruth took of the assault. And if we turn to the only other deposition that has been taken with respect to a witness at that concert, so we have Ms. Brewer, we have Ms. Ruth, and Ms. Hallcup. Ms. Hallcup's testimony is not inconsistent with the assault that occurred that day. Ms. Hallcup, she acknowledged that Mr. Carter was the last person, the last of the band to arrive at the hotel that day. That she, in her own post that she made following the concert, she acknowledged that she saw a couple of the band members, one in particular was signing autographs for 15 minutes, and then Nick Carter arrived thereafter. We've never alleged that the assault took place for hours. We're not saying that it could have taken minutes for these events to transpire. And there's evidence to show that. And lastly, there's a lot of witnesses that plaintiff has been trying to reach, connect with. We have discovery that's ongoing, some who have made those posts, and we've been working diligently to do that. Discovery has been delayed for a number of months in this case because of the anti-SLAPP proceedings that were in the beginning. And since this motion, we've taken 2 depositions, one of a person who has asserted that she was raped by Mr. Carter on at least 3 occasions and contracted HPV, and another who has asserted that she has been given a date rape drug from Mr. Carter. We do plan on taking Mr. Carter's deposition as well. We want to coordinate with Ms. Repp's counsel and Ms. Schumann's counsel to make sure that everyone has a fair opportunity to examine Mr. Carter in these consolidated matters. And so if you're, in the end, more discovery needs to be done in this case. But regardless, there is evidence here to show that there is a genuine issue, a material fact that needs to be before the jury in this case. Thank you, Your Honor.
Thank you.
Your Honor, first and foremost, those 2 so-called victims, we've taken their depositions, and this court will see that they are just as not credible as Shannon Ruth. As it relates to Molly Hallcup testified specifically, which Mr. Boscovich was at her deposition, that the buses arrived back to back within minutes at the Four Seasons. He doesn't dispute that. Shannon Ruth doesn't dispute that. So it's a factual possibility that Mr. Carter could have or did sexually assault Shannon Ruth at the Tacoma Dome, because based on their own reliance of Eleanor Brewer testified that Shannon Ruth was gone for an hour and a half after the concert before she comes back to the car looking disheveled. So the timelines do not match up. And from day one, we've said that this is all completely fabricated. Mr. Boscovich also didn't address that the NIED claim is improper under Nevada law. That's something that's been established and clarified by our court as recently as 2023, even though it's an unpublished opinion. You can only bring an NIED claim as a bystander. It can be emotional distress damages, can be a component of damages or an element of damages on a simple negligence claim, which they did not allege in their complaint. So that alone should at least warrant summary judgment. And Mr. Boscovich also has not disputed all of the facts that we set forth in section K of our reply that are deemed established based on Ms. Ruth's own admissions and her failure to dispute those in opposition. So at the very least, we would ask this court to grant the alternative relief of 56G.
Thank you very much. Court sticks with the initial inclination, denies without prejudice, defendant/counterclaimant Carter's motion for summary judgment on plaintiff Shannon Ruth's claims. Primarily based on 56D relief. Discovery is still ongoing. Additionally and/or alternatively, the court denies it without prejudice because genuine issues of material fact exist as set forth in the evidence submitted both by the moving party and plaintiff Ruth. As to 56G relief, the court exercises its discretion, declines without prejudice to grant that request. As to the negligent infliction of emotional distress claim, substantively, whether you characterize it as a, quote unquote, negligent infliction of emotional distress or simply negligence, it certainly does state a claim. And there is, either 56D relief or genuine issues of material fact such that whether it's negligent infliction of emotional distress or simply negligence, there's certainly notice already provided in the pleading itself. At the very least, there's a negligence, if not negligent infliction of emotional distress claim asserted. So the court denies summary judgment as to that claim as well. Plaintiff's counsel prepare that order, submit to defense counsel for review and approval.
Thank you, Your Honor.
Thank you.